Hello, this is Alexander Cross, attorney, criminal law here in the San Francisco Bay Area. Be sure to subscribe to our YouTube channel if you would like to learn more about criminal law offices of Cross and Associates. Well, we received an interesting inquiry here on our channel. This has to do with battery and domestic violence. Let's see. During an argument, I ended up hitting my 16-year-old son. My wife tried to intervene, and I hit her as well. Later, the police came and arrested me. Well, I'm pretty sure now that this coronavirus is going on, this is probably happening more and more often since families are basically quarantined together. First of all, let me focus on the battery against the child, the 16-year-old. Well, you can legally, corporal punishment is still legal here in the state of California. However, you essentially have to limit yourself to using an open hand. You can't be using objects, no belts, no shoes, no bats. But generally speaking, corporal punishment is still okay here in the state of California. Usually you have to use an open hand, but it still needs to be reasonable to the alleged infraction of the committed by the 16-year-old. The 16-year-old drops a pencil, you can't start whacking him. He does something bad, something that I'm not even going to mention here. Well, then yeah, there might be a basis, but I need to know whether or not this punishment was excessive to begin with. The reason is because if the punishment were deemed excessive, well, then you could be charged with child endangerment or child cruelty, which would be a violation of Penal Code Section 273A, parentheses A, here in the state of California. That would be a felony that carries up to 6 years in state prison. Now, the other one, there's not going to be much dispute on whether or not it's legal or illegal. You can't be hitting your spouse. You can't be hitting your wife. You can't be pushing your wife. You can't do that. Domestic violence, that means battery upon your spouse, can be filed as a misdemeanor, or it could be filed as a felony. Generally speaking, if there is no traumatic condition, no cuts, bruises, no marks, broken bones, if there's no traumatic condition, like let's say a push or a shove or something like that, generally speaking, that would be a violation of Penal Code Section 243, parentheses E, parentheses 1, as a misdemeanor. That carries up to 1 year in the county jail. But if your wife, ex-wife, girlfriend, ex-girlfriend, you get the picture, if they suffer any kind of injury, any kind of traumatic condition, anything to where the police could take a picture and see a mark, okay, that would be a felony under Penal Code Section 273.5. That carries up to 4 years state prison, and you'd potentially have to take domestic violence classes for up to 1 year. So, and of course, it is considered a crime of moral turpitude. So if you happen to not be a U.S. citizen, this sort of offense could potentially result in deportation, exclusion from the United States, or denial of naturalization. Now, in a situation like that, it's very possible that it all happened as an accident. What if you were in process of spanking your 16-year-old? Well, I don't know how many 16-year-olds get spanked, but I guess it happens. Let's say it was not excessive. Let's say you were hitting the 16-year-old with an open hand, and maybe your wife jumped in and tried to grab you, and maybe just on a reflex you might have accidentally pushed her, or you were just protecting yourself because maybe she started hitting you. Well, in a situation like that, then it wouldn't necessarily be child cruelty, wouldn't necessarily be against the law to spank your kid, and the domestic violence in that specific situation could be chalked up to self-defense based on her attacking you because she was trying to defend her kid. I mean, there are some possibilities here. That's why it's very important to enter pleas of not guilty, order copies of the police report and any other physical evidence that they might have. Then the judge would have to give a new court date to come back and start discussing the matter with the DA's office. There's potential that a private investigator may have to be retained in order to discuss the matter or to question the two victims in the case to see if they may have said something inconsistent from what they may have told the police. And eventually, if that cannot be reconciled, then maybe it's possible that the case may have to be taken to a jury trial, where 12 people from the community would have to decide whether or not you are innocent or guilty. Regardless of that, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross & Associates. But if you've been accused of having committed a crime here in the San Francisco Bay Area, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. See you then.